Note that case names should always be in italics. I did had time for this video. Land law. Lease is legal. 307 New Zealand law video by smart lawyers. A lease is a legal arrangement granting exclusive possession of land to a tenant, leasee, for a fixed term, while a license merely permits personal use of the land without creating a legal interest. Leases provide stronger rights, such as the ability to transfer or sublet and protection under property law, whereas licenses do not. Courts focus on the substance of the arrangement, particularly exclusive possession, rather than labels. For example, in Roddick v. Smith and Fatat Limited, Commissioner of Inland Revenue, courts ruled agreements as leases despite their labels due to the substantive rights granted. This distinction affects registration, rights, and obligations under property and tax law. This is all explained in simple. Lease, renting an apartment for a year. Lessor, the landlord who owns the apartment. Leasee, the tenant renting the apartment. Term, the 1-year period the tenant can use the apartment. Reversion, the landlord's right to get the apartment back after the lease ends. Transferee of the reversion, if the landlord sells the building, the new owner becomes the lessor. Assignee of the lease, if the tenant moves out early and another person takes over the lease, that new person is the assignee. Sublease, if the tenant rents out a room in the apartment to someone else while still living there. Exclusive possession in simple English. Exclusive possession, O, refers to both the actual control over the property and the legal right to control it. Factual versus legal right, O, factual exclusive possession, simply means you have control over the property and can keep others out. O, legal exclusive possession, means you have a legal right to control the property, which gives you any stake in the land. Determining exclusive possession, O, first, check if someone actually has exclusive control over the property, factual possession. O, then, determine if this control is backed by legal right, legal possession. Personal right might give control without any legal interest in the land. Legal right gives a legal interest in the property, such as a lease. Summary. Factual exclusive possession can be either a personal right or legal right. Legal exclusive possession confirms an estate in the land. Lease versus license in simple lease. Definition: an arrangement where one party, the leasee, is allowed to use another party's, the lessor's, property for a set period of time. Type of right: provides a legal interest in the land. Characteristics: O, proprietary right. This means the lease is a strong property right that attaches to the land. O, transferable, can be assigned to others, and the rights and responsibilities continue with the land. License. Definition: a permission given to someone to do something on another's property that would otherwise be illegal. Type of right: provides only a personal right to occupy or use the property. Characteristics: O, personal right. This means the license is a weaker, personal right that doesn't attach to the land. O, non-transferable, cannot be assigned. It's only valid for the person it was granted to. Why property rights are stronger? Leases are stronger because they are legal rights that run with the land, meaning they can be transferred and continue to bind future owners of the land. Licenses are weaker because they are personal rights that don't attach to the land, so they are not transferable and only apply to the specific person who was granted the license. Proper creation of leases in simple formal creation. O, deed of lease, a legal document signed by both parties to create the lease. O, registered lease instrument, a lease that is formally registered with the land registry. O, special statute, leases created under specific laws or regulations. 2. Informal creation. O, agreement to lease, a less formal agreement to lease the property, which can be less strict but still valid. 3. Legal considerations. O, Section 24 of the Property Law Act 2007, the section affects informal agreements for land transactions, including leases. O, Section 26 of the Property Law Act 2007, the section allows the doctrine of part performance to apply, meaning informal agreements to lease can still be enforced if part of the agreement has been carried out. Sublease versus assignment in simple. 1. Assignment. O, the tenant, leasee, transfers all their rights and responsibilities under the lease to someone else, assignee. O, the assignee becomes the new tenant and deals directly with the landlord, lessor. 2. Sublease. O, the tenant, leasee, creates a new lease with a new tenant, subleasee, for a part of their lease term or property. O, the original tenant remains responsible to the landlord and becomes a landlord, sublessor, to the subleasee. O, the sublease is a separate agreement, but the original lease, head lease, remains in place. Guarantor. A guarantor is someone who promises to fulfill the lease obligations if the tenant fails to do so. Example, a company director guarantees a lease for the company. If the company doesn't pay rent, the landlord can seek payment from the director. Essential elements of a lease in simple. 1. Grant of exclusive possession. O, the tenant, leasee, must have the right to use and control the property without interference from the landlord, lessor. 2. Definite term. O, the lease must have a clear start and end date, or at least be for a period that can be easily determined. O, note, Section 212 of the Property Law Act 2007, PLA 2007, imposes a maximum limit of 10 years for leases unless specified otherwise. 3. Certainty of premises. O, the property being leased must be clearly identified so there is no confusion about what is included in the lease. 4. Properly created lease. O, the lease must follow all legal requirements and formalities to be valid. This often involves a written agreement signed by both parties. Simple explanation of key sections in the Property Law Act 2007, Sections 240, 241 PLA 2007. Purpose. These sections formalize the concept of privity of estate when a lease is assigned. Privity of estate. This means that the rights and obligations of the lease passed from the original leasee tenant to the new leasee assignee when the lease is transferred. Sections 231, 233 PLA 2007. Purpose. These sections formalize the concept of privity of estate when the ownership reversion of the property is transferred. Privity of estate. This means that the rights and obligations of the lease passed from the original lessor landlord to the new lessor transferee when the ownership of the property is transferred. Simplified breakdown. 1. Privity of estate on lease assignment, sections 240, 241. O, when the tenant transfers the lease to someone else, new tenant, the new tenant takes on the lease's rights and obligations. 2. Privity of estate on reversion transfer, sections 231, 233. O, when the landlord sells the property to a new owner, the new owner takes on the lease's rights and obligations as the new landlord. Simple examples. 1. Interest in land. O, valid lease, renting an apartment with a formal lease agreement granting exclusive use and control. O, personal privilege, letting a friend temporarily use your driveway without any formal agreement. 2. Cross lease. O, same person as lessor and leasee, two homeowners in a duplex with cross leases for each other's units. O, different people, renting an apartment from a landlord or property management company. Key cases. City of London Court v. Fell, 1994, highlights the dual nature of leases. Westpac Merchant Finance v. Winstone, 1993, another important case in lease law. Gibbons Holdings v. Wholesale Distributors Limited, 2007, discusses interpretation of leases. Melanesian Mission Trust Board EMP Society, 1997, emphasizes the importance of wording and context in lease documents. Bullet, lease as a contract, binds the original parties. Bullet, lease as an estate, obligations and rights pass to successors. Bullet, courts, use contract rules to interpret leases, especially in commercial cases. Emphatic Limited, in Lick v. Commissioner of Inland Revenue, 2002, 3 MZLR 648, CA, the court's decision was, decision. The agreement between Bohemian Quarries Limited and Atlas was found to be a lease, not a license. Reasoning. Exclusive possession. The agreement granted Atlas exclusive possession of the quarry for a fixed term, which indicated a lease rather than a mere license. Intention of the parties. The court emphasized that the actual intention of the parties regarding substantive rights, not just the language used in the document, was crucial. The existence of exclusive possession at a fixed term pointed to the creation of a lease. Impact. This distinction was important for determining GST liabilities. If it had been a license, GST would have applied. As a lease, it did not. Issue. Whether an agreement allowing a quarry operator to use land was a lease or a license. Background. Puhinui Quarries Limited. Puhinui owned the property with the quarry. In 1991, Puhinui granted Atlas the right to operate the quarry for 12 years, renewable for 3 more years. The agreement had limitations on access and use of the quarry. Puhinui later agreed to sell the property to MT Wellington, subject to what was called a license to Atlas. Key points. Purpose of distinction, determining if it was a lease or license affected GST liability. A license would incur GST, but a lease would not. Court's findings. Intention versus exclusive possession. The court found that the intention of the parties to their relationship is less important than the substantive rights granted. Exclusive possession is crucial. The distinction lies in whether the occupier has a right to exclude everyone, including the owner. Even if the agreement is termed a license, if it grants exclusive possession, it could be considered a lease. Indicators of a lease. A lease generally includes exclusive possession for a fixed or periodic term. The presence or absence of rent is a factor, but not the sole determinant. No tenancy if there is no intention to create a legally binding relationship. Statutory restrictions prevent tenancy. Possession rights are terminated for reasons unrelated to the occupation of the land. Conclusion. The terminology used by the parties, lease or license, is less important than whether the agreement grants exclusive possession. Restrictions on land use do not necessarily negate exclusive possession. Street v. Mountford, 1985, AC 809. Summary issue. Whether an agreement titled a license agreement was actually a lease or license. Background. Street granted Mountford a license to occupy 2 rooms at a weekly rent, with 14 days notice required for termination. The agreement was labeled as a license agreement and stated that it did not create a tenancy. Street sought a court declaration that Mountford had only a license. Mountford appealed to the House of Lords. Court's findings. Key point. The substance of the agreement mattered more than its title or wording. Relevant consideration. Whether the agreement granted exclusive possession for a term at a rent. The intention of the parties should be understood in terms of the substantive rights created by the agreement, not just the form of the document. Conclusion. The appeal was allowed. The agreement was found to be a lease, not a license, because it provided exclusive possession for a term at a rent. Important principle. The real intention of the parties is determined by the nature of the rights granted, not by the labels or terms used in the agreement. Why it's important to distinguish between leases and licenses. 1. Binding rights. Lease. If a leasee owns a leasehold estate, this right binds the lessor's future owners. License. A license does not bind future owners. 2. Registration. Lease can be registered under the Land Transfer Act 2017, LTA 2017. License cannot be registered. 3. Assignments and subletting. Leasees can assign, transfer, or sublet the property. Licensees cannot assign or sublet unless specifically allowed. 4. Legal rights. Leasees have exclusive possession and can sue for nuisance or trespass. Licensees might not have the same rights to sue for nuisance or trespass. 5. Cancellation. Lease. Sections 243 to 252 of the Property Law Act 2007, PLA 2007 provide a process for cancellation. License. Similar rules apply for licenses entered into after January 1, 2008, offering more protection. 6. Rent and seizure. Lease. Lessors cannot seize property for unpaid rent. License. Licensors might be able to seize goods if the license fee is unpaid. Note, seizure was abolished by Act 265 PLA 2007. 7. Tax implications. Lease versus license. The distinction can affect GST and income tax considerations. Summary understanding whether an agreement is a lease or license impacts rights, registration, assignment, legal claims, cancellation procedures, and tax matters. Roddick v. Smith, 1959. Case summary in simple English. Background. The Smiths created a document that seemed to give Roddick a license to use their property. Roddick argued that the document was actually a lease despite being labeled a license. Court decision. The court looked at what the document actually provided, not just its label. They found that the document gave Roddick exclusive possession of the property, which is a key feature of a lease. Therefore, the document was treated as a lease, not a license. Key points. Exclusive possession. This is the main factor distinguishing a lease from a license. A lease grants exclusive possession of the property, whereas a license does not. Label versus reality. The court decided based on the actual rights and intentions of the parties, not the wording of the document. Legal right. If someone has a legal right to exclusive possession for a fixed period, it's considered a lease. Quote from the case. A right of exclusive possession is secured by the right of the leasee to maintain ejectment and, after his entry, trespass. A tenant for a term or from year to year or for life or lives can exclude his landlord as well as strangers from the demised premises. Summary. Lease versus license. The court focused on whether the agreement gave exclusive possession, which made it a lease despite the document's label as a license. Summary of the lease topic. 1. What is a lease? Lease, a legal agreement where one party, the lessor, grants another party, the leasee, the right to exclusively possess land for a specific period, which is usually shorter than the lessor's ownership period. Leasehold estate, temporary interest in the land, which reverts to the lessor after the lease ends. Lease versus tenancy. A lease with a defined term is a lease. A tenancy typically has an uncertain or periodic term and is often used for residential arrangements. 2. Terminology. Lease, right to exclusive possession for a certain period. Lessor, freehold owner or landlord. Leasee, tenant who holds the lease. Term, duration of exclusive possession. Reversion, right of the lessor to reclaim possession after the lease ends. Transferee of the reversion, new lessor after the reversion is transferred. Assignee of the lease, new leasee who takes over the lease from the original leasee. Sublease, a new lease granted by the leasee to another party, creating a subordinate leasehold interest. 3. Dual nature of leases. Contract and estate. A lease is both a contract binding the original parties of an estate and land with obligations extending to successors. 4. Proper creation. Formal creation. Leases can be created by deed, registered lease instrument, or special statute. In formal creation, agreements to lease can be valid but are affected by Property Law Act 2000.